Hey everyone, welcome to another episode of Darshan Talks. I'm your host, Darshan Kulkarni. Today's interview is brought to you by the Kulkarni Law Firm, and I'm excited to actually have with us Paul Thaler, who is a lawyer in Washington, D.C., as you can tell from his background, which is amazing. We had to spend a significant amount of time trying to block his background because it was shining, glaring, and amazing. He's the managing partner of the D.C. office of Cohen Seglius, and he specializes in research misconduct matters. You can actually go to their website at www.cohenseglius.com, which I think might be interesting for you guys. I thought the conversation was going to be really, really interesting because we do a lot of conversations around clinical research, but to talk about the process of research fraud would be very, very interesting. I do want to say that we would love if you write in, leave a comment, subscribe. It helps with the YouTube algorithm. You can always find me on Twitter at DarshanTalks. Go to my website at DarshanTalks.com. Also, you can go to KulkarniLawFirm.com as well. I'm really, really happy to have with us Paul. Paul, tell us a little bit about yourself before we jump in.
Sure. Hi, Darshan. Thank you so much for inviting me today. It's a pleasure. Myself personally, I'm a Washingtonian, fifth generation. My family's been here a long time. And I am an attorney here in DC. Been practicing for a while. You'll see if you go to the website, you can see, read all about my professional background. I've recently become a grandfather about a year ago, so that was very exciting. I know it's shocking to look at me that I could possibly be a grandfather, but I am.
Well, I thought it was Brad Pitt, so I can't tell still.
I get confused with him all the time, and I try to convince my wife that, in fact, I do look a lot like Brad Pitt. Yeah.
So it's you and Dr. Fauci, I believe.
That who look like Brad Pitt.
Exactly.
Okay, it's fine with me if that's your story.
But let's start from the beginning. We're talking about research fraud, right? Well, whenever I talk to a lot of clients, my clients go, is it really such a big issue? Is it really something that comes up often? Why am I worried about research fraud? So can you talk a little bit about how common this issue is?
So research misconduct is what I practice in, and it's now about 90% of what I do. And I have a team of half a dozen lawyers here at Cohen Seglius and who are working with me on my cases. I got started representing scientists accused of research misconduct 30 years ago. And that's about when ORI, the Office of Research Integrity, part of HHS, Department of Health and Human Services, it's about when it started. So I've represented many, many hundreds of scientists all over the country and now internationally accused of research misconduct. What does that mean? If someone alleges that there's been falsification of data, fabrication of data, or plagiarism in connection with scientific research, and especially if that research was funded by the Public Health Service, by federal funds, then there's a whole process that the scientist has to go through with the institution that took the funds to determine whether or not, in fact, there was research misconduct. And if so, what should the sanctions be? So you can imagine the impact on a scientist. First of all, going through this is a threat to their career, to their reputation, to their science. And just having to go through it at all is very difficult for them. The prospect that there might be a negative finding is daunting, as is for you or me. If there's a threat to our license to practice law, you can imagine how awful that would be. Same thing with the scientist. This is a threat to their career, and it's very serious. And we take it very seriously. There are protections built into the process, for instance, to protect their confidentiality. Why is that important? Because we don't want the outside world that's not participating in the process to even hear that there are allegations, because it could very well be that it's false, that there is no research misconduct. And you certainly would want that particular scientist to come out of the process unscathed so that they can resume their efforts in science and, in theory, help us all. And that's one of the things I really like about my work, is that the people I help are some of the most important scientists, and also some junior scientists who are contributing to the world of science, and that benefits everybody. So we want to protect them as best we can, but the world of science and the funding for it is important too. So we have to make sure it's protected as well.
So let's start from that beginning. You talk about the idea that someone alleges that there's research fraud. Who is this someone? Is it typically a sponsor? Is it typically the IRB? Is it the CRO? Or is it a government official?
It can be anybody. And in fact, what's interesting is that it's not that person called the complainant also has confidentiality protection. Why? Because frequently it's someone at the same institution, and we don't want that person to suffer retaliation for making the complaint. We want to foster the process. We want to encourage people, if indeed there is research misconduct, it should be brought to the attention of people. So the person at each institution responsible for all of this is called the RIO, the Research Integrity Officer. They receive the initial allegation and make an early determination whether it's possible it could be research misconduct. If so, then the process ensues that includes at the beginning a committee called the Inquiry Committee, made up of 3 colleagues at the institution typically, and they determine whether or not it could be found by a subsequent investigation committee to be research misconduct. If so, they pass it on to an investigation committee, and they do the actual investigation.
But you're saying this is happening, for example, at the sponsor side, where they'll have this committee? Because a lot of sponsors I work with, at least the smaller sponsors, don't have that level of sophistication. They have at best like a project manager who's going, I think there might be fraud issues. On the other hand, I know that most sites don't have that level of sophistication, and I know CROs, again, the clients I don't. So it sounds like you're dealing with some pretty sophisticated organizations who have that level of systems built in.
Yeah. So any institution receiving federal funds, and typically the institutions I'm working with are universities and hospitals. If they receive federal funds for research, then they must have a process that typically will mirror the federal process set up in the CFRs, the Code of Federal Regulations, guiding institutions receiving funding from Public Health Service, PHS. So each of those institutions will have this process set up. And you were asking about who the complainant is. It could be anybody, and we don't know, and it's not supposed to be important. The critical thing is you look at the actual allegation itself, you look at the data, everything, all of the lab notebooks and everything is sequestered at the very outset of the process to be given to the various committees to review. So there is a fairly tight process in place, and it's all set up as a result of things that happened in the 80s, and Congress looked at it. Congressman Dingell from Michigan, I think Al Gore was involved as well, and they established this oversight to protect the funding that's used in scientific research.
Interesting. So so this is happening, like you said, at large academic institutions and the like. I'm often dealing with smaller ones who may not have that same structure built in for various reasons. So,
most of the cases I have are at universities and hospitals, almost all of them, because those are the ones that are receiving federal funding. If it's a private company, then they could have independent obligations if they're receiving federal funding, and they will be expected to have something of a process. They could refer to the ORI website and see what it recommends for the process, but they're going to be expected, if they want to keep receiving federal funding, they're going to be expected to have a process that looks into the allegations properly and makes it a determination whether or not there's misconduct.
Interesting. So let's assume that this is a university setting, right? And there has been an allegation of research fraud. Could you walk us through what that process looks like? Because you mentioned that there is obviously some privacy protections that are built into the system. Do people start exchanging CDAs at that point? Like what are we dealing with at that point?
Yeah. So the very beginning, it's possible that the respondent, that's the scientist, doesn't even know that it's happening, because, as I said, there's an initial review by the RIO, the Research Integrity Officer at the university. Let's just assume it's a university, at the university. If it is something that could be research misconduct, then a letter will go out to the respondent describing the allegations. They will have a process in place to sequester all of the potential evidence, the lab notebooks, laptops, anything. And that also could happen at the exact same time the respondent's finding out. And what's interesting about that is it seems upsetting and damaging to the scientists, because you're taking away data, you're taking away laptops and so forth. But ultimately, it's for the benefit of everybody, including the scientists. I've had cases where very far down the road in the process, there's an allegation that the respondent, the scientist, actually did something with the underlying data, with the notebooks. And in part, the problem was that they hadn't sequestered properly. And so that opened up the possibility that that could actually happen. Well, if you sequester, then you remove that possibility. So that actually is beneficial to the scientists. Once the RIO has signed off and said, yeah, I think that this could be something that we need to look into, then they put together 3 members of the community, the scientific community, typically other professors at the university, to create this inquiry committee. Now, you and I know the term prima facie in our legal background, but it's essentially determining whether or not on the face of the allegations, it could be research misconduct if investigated. So they look at that connected with whatever is available. And then, as I said earlier, if so, then they pass it on to a new committee, the investigation committee. And they're charged with actually going through all the data, interviewing witnesses, and drafting a report that's then shown to the respondent. Now, what you haven't heard so far is the respondent putting up a defense.
Right.
Step of the process, it's the university reviewing things, talking to people, but where's the defense? This is not the world of Kafka. You know, here in the United States, people are supposed to be able to defend themselves against allegations. So the process is set up so that the respondent typically doesn't really say much until they're interviewed by a committee, and then they have an opportunity to comment on draft reports. At that point, they can offer up explanations or arguments, but it does seem inconsistent with our general notion of due process and fairness. They are supposed to get the entirety of the record at that point of the investigation draft report, and that again gives them an opportunity to see what was said about them. They don't appear at the interviews, the respondent. They don't get to cross-examine anybody. But at the conclusion, when they're reviewing the record, they can see what was said at these interviews. Once the respondent has commented on a draft report, then the investigation committee prepares its final report, and it's handed up the chain in the university that makes the final determination and imposes sanctions, which can go anywhere from, nothing to supervision, to you got to take some courses, to ultimately some people get fired from their job. Some people have had other harsh things. If ORI, the Federal Office of Research Integrity that I was talking about, if it then receives the report from the university, if it agrees and says, yes, there's research misconduct, the worst penalty from them is getting debarred. The scientists can get debarred from getting federal funds or working in federal grants for a period of time. Usually it's a number of years. There have been occasional, much harsher, lifetime bans on getting federal funds. But that's in a very short and small nutshell how the process is managed through the university.
So that's happening at the university level. At the same time, is the university itself defending these charges from in the context of the sponsor and the like?
Well, if you think of it, it doesn't behoove the university at all to have a scientist on its faculty who is found to have committed research misconduct. So it does have an independent obligation to make sure it does a proper investigation, but they don't take joy in having a finding that their scientist, their professor, has committed research misconduct. So, but they do have the obligation, because ultimately, if you're going to accept federal funding, then you have to go through this process in order to keep getting federal funding. That's the harshest remedy, penalty to the university, is if they don't have a proper process, then possibly the federal government would determine that they can no longer receive federal funding for research.
So one of the interesting things you mentioned a little bit earlier was this idea that people will take lab notebooks and the like, which to me talks more about preclinical research, early stage research. Are you seeing as much of that in clinical research, or is that more protected only because there are all these controls in place, whether you're talking about IRBs, whether you're talking about monitoring visits from CROs, or is it basically half of one, six of one, half a dozen of the other?
Yeah, it's pretty much every kind of research that the federal government is funding, and the lab notebooks reflect, in theory, the data that is the focus of the allegations. Keeping in mind what I said earlier, an allegation of research misconduct is not just a general, you're a bad scientist. It's very specific. There's an allegation that particular data was fabricated, that particular data was falsified, or that there's plagiarism. That's it, as far as ORI is concerned. So that's why you want to seize, well, in the process, they seize in a sequestration the underlying, the lab notebooks, which should have somewhere in it the data, the laptop, which should have indications of efforts to develop an article, for instance, for a journal, and to see how that data was incorporated and whether or not they can even figure out if it was in fact falsified or fabricated within the laptop. So it's any kind of research that's funded, but it's very specific allegations: falsification, fabrication, or plagiarism.
So this works if there is federal funding. What happens if there's no federal funding? Do you?
Universities, yeah, I mean, universities and hospitals will still have a process in place. It doesn't matter that it wasn't federally funded. Each policy at university will provide that if there's an allegation of research misconduct, this is what we do. So all it means at the end of the process, if there's no federal funding, all it means is it doesn't go to ORI or NSF. It just stays within the university. But it still opens up the possibility, frankly, that the professor could be terminated. Now, what's interesting is a lot of universities will take a position that, well, we don't tolerate any kind of research misconduct. So if there's a finding of research misconduct, we're going to fire that professor. Well, keep in mind, there are tenured professors. So now you introduce a new wrinkle to it, because the tenured professors have that layer of protection that they have to, the university now has to go through its own tenure revocation process. So they can't just terminate. You can't just say, I hereby terminate. And I've had cases like that where the university, I don't know if they forget or if they intentionally want to redirect people and just say you're hereby terminated. And I have to correct them and say, well, no, actually, you have to go through your own tenure revocation process, because this particular respondent is a tenured professor.
So this all works in the context of a university. What if it's one private entity against another private entity without having federal funding?
If that's the case, and if the private entity doesn't have any kind of process, then it's a free-for-all. I mean, I don't have much occasion to have had cases like that.
Okay.
But a private entity can create its own rules internally on how to address issues, all sorts of issues, like HR issues. I mean, there are all sorts of things that they can do. They don't have the obligation to, under your scenario, to the federal government, because there's no federal funding. So they're not required to have that process in place. I would suspect many of them do have something of a process, but they also, keep in mind, they don't want researchers to falsify data or fabricate data. Sure. So they're going to want to figure out what happened, and if so, take steps to make sure it doesn't happen. Because ultimately, if they are in the marketplace and they're selling something, it turns out someone, a reader or another scientist somewhere figures out that they just made stuff up, well, and that was the basis for their new invention. That's going to come back to haunt them. So they should have things in place, but in my world, the people who are coming to me are the ones that are involved in a process.
Makes sense. It's funny. I'm usually brought up in the other scenarios, which is interesting. It's a nice dichotomy, if you will. So I find it fascinating because in my world, it is a little bit of a free for all. Yeah. And people are allegations are being thrown, and you're defending against allegations that don't have proof to them. And it's kind of interesting to watch. So when you talked about
what process do they do?
So in my case, it'll be things like, we're going to report you to the IRB. Okay. And then the IRB will, I've been in scenarios where the IRB will, for example, withdraw approval for the study itself. And you're kind of going, so what does that mean for us? And if it's a large IRB, does that land up in a scenario where all the studies that site is doing are revoked, or is it just for the principal investigator or some other variant?
But they have now introduced another entity. The IRB is going to have its own process to determine what happened. But have you had occasion when it's just a private company and there are these concerns and an IRB is not involved?
So the way the private companies handled it, in my case at least, was they will make the allegation, but they will basically say, we're stopping research with you, and we will report you to the IRB as part of our process itself. So that's the extent of their process.
But you see, that is somewhat similar to the other process that I was describing, the penalty being, we're pulling the plug, we're taking away your funding.
Correct. Yeah. But the difference is, at least in your case, there is a structure for saying, I'd like to challenge this. In my case, what I'm dealing with often my challenge is basically a contract dispute at that point, as opposed to I have a process to challenge the whole scenario.
Have you seen litigation erupt as a result of that?
I have seen allegations of research fraud resulting in litigation. I have seen, and not just from a contractual perspective, but what are the ramifications thereof? Because are you going to just inform, for example, ORI? Or are you going to go FDA? Or are you going to cause the IRB to report to OHRP or AHRP or whatever it's going to land up being? So that lands up being a very, very interesting, convoluted mess that you're often, and it's never just one situation, right? Because if one sponsor says that and they report it to the IRB, now you suddenly have the other sponsors going, what does this mean? And now they are also a little gun shy, and they might start withdrawing studies. So it creates a cascade effect.
So and forgive me if I'm now interviewing you, but I'm curious. Are the people who are respondents in those situations, are they protected, their confidentiality, or does everyone know who it is and that?
So you take your efforts, and that's exactly the problem. You don't have the same confidentiality provisions, which is why I was asking you if you guys signed a CDA or an NDA, and that's not what exists, right? You have your confidentiality provisions under the clinical trials agreement. That might cover it to some extent, but at some point, if the sponsor believes that they need to report it, they will, and that reporting is required under federal rules. So if that's true, now the IRB suddenly may be required to report it as well. So what are the questions you have? And the question is, are you really required to report it is the question you land up facing, because is it still an allegation, in which case we should have a chance to respond, or is it a confirmation, in which case how did you confirm without asking us, without giving us a chance to respond?
Well, you have a lot of stakeholders involved, and so I start identifying all the different people and entities that have an interest in what's happening here.
Yeah.
And so much of my work is protecting particular people involved in these things, and the issues that we're concerned about concern their careers, their reputations.
Correct.
And so as you describe what you have been doing, that pops into my mind that, well, what about this poor guy who's mixed up in this, and people are, identifying him, or that association with research misconduct or any kind of IRB violations or fraud of some sort connected with science is so serious that I routinely compare it to McCarthyism. The Senate trials of people accused of being accused of being communists in the 1950s, and the damage that was caused by a mere allegation.
Exactly.
So many of them had no ties to communism or Communist Party, and just the fact that in a public setting, someone said that person is a communist.
Exactly.
Once accused, twice denied. Same sort of phenomenon here. If third parties learn that a particular scientist has this allegation against them, that's just damaging in and of itself. That's why confidentiality is so important.
It is. And you don't have those same protections because you are involved. For example, the confidentiality provisions may be part of that CTA, but the CTA also says that the sponsor may have the right and or the responsibility to report. So to what extent, at what point should they report is the question. Is it just
there's a balancing test there, because we do all want good science, and we want science that's not negatively impacted by fraud or by misrepresentation. But on the other hand, we also in our country like to protect people's rights and interests and have due process set up so that they can be protected. So there is that tug there in what you described.
And that is the reason why we have to continue this conversation, because this is so interesting, and we blew through the time so quickly, and it feels like we're just getting to the more interesting parts of this. Because I'm going to have I'm going to preface the conversation that we'll hopefully have the next time around, which you hinted at, which is and you hinted at this, to be fair, before we got on, but it was on the China initiative and how there was scientists who were pulled into alleged research fraud issues that may not have even been involved, and what are the implications of that, and where are we now? So this should be a very, very interesting conversation. I hope people tune in to this one and to that one. But before we go, a couple of things, Paul. Number one, can you tell people where they can reach you?
Sure. The easiest way is to go to this website address. On the website, that's my law firm, you can find me in the attorneys section. It says Our People. Go to T for Thaler, and you can read about me, my background, but also there's contact information and a link to email. So it's very easy to contact.
Perfect. And last question, what would be your parting words?
My parting words is, don't forget that there are a lot of interests involved in these sorts of allegations, that it's not just every scientist is a bad guy who has an allegation lodged against them, and keep an open mind and afford everybody an opportunity to defend themselves.
Very, very cool. Paul, thank you so much for coming on. This was amazing.